Yes, we will call the meeting to order, and will the secretary please take the roll?
That's not going to put me to sleep.
Representative Curtis.
She'll be 15 minutes late.
Representative Flynn.
Here.
Representative Gursky.
Here.
Representative Harris.
Here.
Representative Hill. Representative Ingraham.
Excused.
Representative Jacobson. Representative Lenz.
Here.
Representative Pearson.
Here.
Representative Redfield.
Here.
Representative Richner.
Here.
Representative Vance.
Excused.
Representative Wagner.
Here.
Representative Pease Lopez.
Here.
Representative Smith.
Here.
Chairman Howard.
Here. Ladies and gentlemen, we will be hearing 4 bills today: 340, HB 340, 341, 342, and 343. The sponsor of the bill and I have came to a joint decision that without objection of the committee, the hearings will be combined today because they involve different aspects of the same subject: changes to the state's Montana Marijuana Act. The sponsor asked that we just have one opening statement and one closing statement, and he agrees with the idea of combining these. And we actually consulted with Sue and went through that whole process so that we knew that we were doing the right thing. Is there any objections from the committee? Okay. For the people who plan to testify, if you support or oppose more than one bill, one of the bills, please just come to the podium once. You may speak on any of the bills at any time, but please be as clear as possible in your testimony about which bill or bills you support or oppose, and why you support and oppose those bills. If you support some bills and oppose others, you can come to the podium as both a proponent and an opponent, if you wish. Again, please clearly state which bills your testimony applies to. And everyone testifying should state their names and spell their last names for the official committee record. Also, I'll tell you that the mics are not real loud, so please do pull the mic down so we can clearly hear you. Just be understanding that we are recording this. It's video and audio recorded. Is there any questions from the committee? Yes. Go ahead, Sue.
Mr. Chairman and members of the committee, after Wednesday's hearing, when there was a little confusion over terms that are defined in law but they weren't in your bills, I talked with Chairman Howard and we discussed how in the future I might provide you with background information such as definitions that might help you as bills are being considered. So I'm passing out the definitions that apply to the medical marijuana statutes so that as those terms come up today, you'll have them on hand. And then the other thing that I'm passing out is a section of law that one of the bills would repeal. House Bill 343 would repeal a section involving inspection procedures, and because it's being repealed, it's not included in the bill, and I thought you might want to see what that section of law looks like as well. Mr. Chairman.
Thank you, Sue. Would the sponsor like to introduce his bills?
Good afternoon, Mr. Chairman, honorable committee members. My name is Kelly McCarthy, and I'm the freshman representative from House District 51 in the Magic City. Now, I've got some handouts for you, but Ms. O'Connell scooped me on one of them. I wanted to give you a copy of the part that's repealed because you don't have a picture of that in front of you, but since she's already done that, I'll skip that. The other thing I'm handing out is the original court injunction that we're going to be talking a lot about, and I just wanted you guys to be able to look at the same page that I was looking at as we go through this stuff. So, with the chairman's permission.
You may.
honorable committee members, well, you have the privilege of seeing me present my first bills. So I picked a couple softball topics to start off to help me ease me into the legislative process. We have 4 bills to present today relating to medical marijuana, as the chairman alluded to. We have spoken about this a couple times to set some ground rules. Hopefully won't spend any more time than necessary on the matters. One of the things, I'm only going to make you sit through my opening remarks once, and I'll try to close. Actually, we're not going to close on each bill in turn. I'll just close at the end, if that's good. The chairman and I also discussed that we'd be limiting testimony to proponents and opponents to 3 minutes each to help us move along. But I'll let him confirm if he feels that that's still prudent. There was a concern at the time that we would have hallways full of people, and it doesn't seem like we've done that. So I'll let the chairman make that decision if he wants to hold to that. I also do want to thank the chairman for his assistance in helping set the tone for the day. This subject matter has been divisive and disruptive in the past, but by talking early, I think we managed to keep it fairly low-key and focused only on the technical issues that we're going to need to deal with today. So I thank you for that, Mr. Chairman. First thing, I need to note that each one of these bills carries a legal review that highlights concerns with the Federal Controlled Substances Act. And I acknowledge that the federal law has supremacy over our state laws on this matter, and I do discourage anyone from violating federal law. However, federal law could change soon. There are bills in the U.S. House right now that would pass management of marijuana back to the states when the states have laws covering that. So that would apply to the state of Montana. So my hope is that we will have something in place that's workable when that occurs. With that, a little bit about myself. I come from a fairly conservative background. Most of my adult life I've served in the intelligence community, and I've even supported drug interdiction efforts in the past. My second career is in the banking industry. So on paper, I seem a very unlikely person to be tackling these matters. I was asked by a few people, is this a constituent issue? And it is. I do have constituents that came to me and asked me to carry these. I think it would be a temptation for many to keep it at arm's length, but I do have a little bit of a personal family tragedy that kind of helped me see this through a different lens. And so it just helped me to, I guess, gain the courage to come forward with this. I should also point out that I'm not an expert in almost anything we're dealing with legally here today. So while I'm happy to make an attempt responding at any questions you have, I have made a concerted attempt to get people in the room who are better versed in the legal gymnastics that have taken place. Our informational witnesses will hopefully include attorneys who have been on both sides of the matter, including representatives from the state's Attorney General's office, which, excellent. He is here. That said, we're not here to argue with the merits of medical marijuana. The voters have weighed in on this issue twice now, and this body has spent a great deal of time debating this during the previous session. We are only here to iron out a few technical tweaks to the current law. Now that we decide, nothing that we decide here today will increase patients' access to medical marijuana, nor will it decrease patients' access to medical marijuana. We're simply seeking to remove from the current law those portions that have been enjoined by the courts and codifying medical marijuana law as it currently exists in Montana. In 2004, voters passed an initiative that allowed patients who could experience better quality of life and more effective management of certain illnesses to be able to use marijuana as a course of their treatment. In the following years, there was a sense that this was most likely being abused by people who simply wanted to have recreational access to marijuana. This exploitation of the people's goodwill offended many in our communities, including legitimate patients. And this led to Senate Bill 423 in 2011 to address the abuses. In 2012, the voters got their second bite at the cherry and supported the restrictions that Senate Bill 423 put in place. At the time of the vote, 5 elements of Senate Bill 423 were enjoined by the courts, and 4 of these will be discussed today. I'll give you a quick definition on injunction because I needed this when I read this stuff. This simply means that the court has found certain elements of this should not be enforced, and so they've said these parts of the law can't be enforced. Now there are opportunities to continue in the legal process, and that could be overturned. But right now, that's why I say we're really not changing any law here. This is exactly how Montana is operating right now. I've got 4 bills, and I mentioned there was 5 things that were enjoined. There is one part of the law that was enjoined, and that was a ban on advertising. I chose not to address the issue because I think that's what caused the most consternation the last time is when marijuana caregivers showed up on every street corner, and that's what offended, I think, the communities the most. So even though that's still enjoined and not enforceable, I chose not to address that. Anyway. When Senate Bill 423 was crafted, it included a severability clause to prevent certain portions of the law from being enforced should they be found unconstitutional. The severability clause allowed the rest of the law to remain intact should this occur. This is essentially what we are working with today, removing those portions of the law ruled to be unconstitutional and keeping the rest of the law intact. While well-meaning, SB 423 was put together in haste after other laws aimed at managing medical marijuana failed. Members of the patient and caregiver community challenged a few elements of the law in June 2011, the District Court of Lewis and Clark County sided with the plaintiffs and enjoined some elements of SB 423 from being enacted. The state appealed the injunction to the Montana Supreme Court. And I've got all these court cases with me, but I chose not to hand them out to everybody. They are available online. And if you need my copies, I'm happy to hand them out. I don't think it helps us much here today to go through all of that stuff. But anyway, the state appealed to the Supreme Court. In September 2012, the Supreme Court reversed the lower court ruling and required the presiding judge to use the rational basis test rather than the strict scrutiny test to determine whether certain provisions of the law were in conflict with the U.S. and Montana constitutions. And that rational basis and strict scrutiny, this is where we're going to need somebody who a little more legally astute than myself to explain that if you have questions on that. In January of this year, the district court ruled a second time and again blocked portions of the law from being enacted, now using the more stringent rational basis test. The Attorney General's office has a 60-day time period that expires mid-March to appeal to the Supreme Court again. To date, they have not made a decision on how best to go forward. And while I do not wish to force their hand, if I'm confused about anything I just said, I really hope that they'll clarify that for us. Regardless, we have an opportunity to put the matter to rest for all concerned here in the legislature. We can get the matter out of the courts and save our state from expending more time and resources on the matter. That the severability clause was written into SB 423 suggests that potential problems may have been foreseen, so the authors sought to put the tools in to fix the law within the bill. That's the end of my opening remarks. I'll go into the specifics of the bills now, if you don't mind. We'll start with House Bill 340. Now, House Bill 340, this deals with the automatic medical board review for any doctor who has provided more than 25 medical marijuana certifications in any 12-month period. And this is currently enjoined by the courts and therefore not enforced. Now, when I researched this, I had a problem with this issue because there's not an automatic trigger for the number of prescriptions for any other medication or course of treatment. This allows a doctor to write as many OxyContin scripts as he likes without ever triggering an automatic board review. So I didn't like the fact that we were singling out one course of medication over another, but my opinion is nearly irrelevant in this matter. But there is a review mechanism. Any person can make a complaint to the state medical board and trigger a review. In fact, last week, a couple of weeks ago, I spoke to a doctor who called me, and and asked if I could include something in the legislation that would prevent out-of-state doctors from flying in for the weekend, holding clinics, handing out certifications, and then leaving. And his concern was there's no follow-up care or anything like that. And this I think is one of the abuses that really caused some consternation in the previous years and led to Senate Bill 423. And so he's a doctor that uses who has used medical marijuana, suggested that to his patients as a course of action for their illnesses, and he was actually offended by this as well. So I told him I didn't want to do that because it goes against the spirit of what we're trying to accomplish here, and not have automatic triggers for specific medications, but explain the review process, and it wouldn't break my heart to see that sort of activity stopped. Anyway, in the court's ruling, this portion was adjourned because of the automatic review trigger was unprecedented. The Board of Medical Examiners did not have protocols for the situations, and it could needlessly damage a physician's reputation when he was not violating Montana law. In this ruling, the state actually agreed with the courts and supported enjoining this provision pending further proceedings on the matter. Now, the court's decision that I handed out, they addressed this on page 9. So you're looking at page 9, section C down towards the bottom, and that's where they explain why they wanted this portion of the law enjoined. If you look at the last three lines 22, 23, and 24 there, it was also, the writing certifications for marijuana users under the former law are concerned that such reviews are unprecedented, could reflect badly on a physician's professional reputation, and would cause these physicians to discontinue making any of the certifications for patients. And then on the next page, on page 10, lines 3 and 4 explains where the state is amenable to the court's temporary enjoining this provision pending further proceedings with the matter. So this particular one is the only one here that's not found constitutionally invalid yet. But the state has agreed that we should probably uphold that point until we get to look at it a little bit deeper. So that's House Bill 340. Are we good? All right, moving on. House Bill 341. All right, House Bill 341, this one deals with two issues, and I actually wouldn't mind a bit of dialogue on one of them, but I'll point that out in a minute. The first one is a restriction of a provider from receiving any compensation for his services and the transfer of products. The second is the transfer of products between providers. In the law, we're on 341 now. If you can flip to, I'm on page 10 again, and if you look at section D, this is a part that was again adjoined by the courts, citing that to prohibit medical marijuana providers from accepting anything in value was actually a violation of Montana Constitution, Article 2, Section 3, persons' inalienable rights. And they've highlighted some stuff in the law, the right to pursuing life's basic necessities, acquiring and possessing property. And then on the following page, actually, if you go to page 12, is something I thought was kind of pertinent. The court is unaware, and I'm on line 17, I'm sorry. The court is unaware of and has not been shown where any other person in any other licensed and lawful industry in Montana, be he a barber, an accountant, a lawyer, or a doctor, who, providing legal product or service, is denied the right to charge for that service and is limited in the number of persons he can serve. So that's what the courts found on that one. On the bill that we're presenting, House Bill 341, this is addressed in page 2 in lines 21, basically lines 21. Now, the part where I kind of took a little bit of liberty here, because when I was researching this stuff, one of the things that I had a problem with was we are dealing with a situation that is legal in the eyes of the state of Montana. And so in the eyes of the state of Montana, we've got providers who might want to go into business, and I couldn't quite understand where they were going to get their initial product to start the business. There's not a way for them to legally acquire it. Well, they can legally acquire it, but one party in that transaction is not doing it legally. So it sort of forced folks to go into the black market to acquire this. And working with our expert bill drafter, Ms. O'Connell, I asked her this question, and I said, well, how has this been addressed in other states? And she dug up something that was done in an interim committee here in Montana that addressed that very issue. So we've actually taken the language from that interim committee and put that in here. And what it allows is a provider to provider transfer now. So neither one of the people, at least in the eyes of the state of Montana, are in the black market. And I've gone under the assumption, I don't know if this is true or not, but that there's enough legal product now in the state of Montana, or that is legal under their eyes, that we can now work within that inventory and not force people to actually break the law to live within the law. So I encourage you to read that part in depth. Give me your thoughts on it, but that's why I wanted to go there. I wanted to cut the black market out of the transaction altogether. And ladies and gentlemen, I think that's House Bill 341. Now, House Bill 342, actually, when the courts decided this one, this is the limit on the number of providers that a caregiver could have. The courts actually addressed this one and the right to earn a living in the same section of Montana law. So all we've done is, if you see line 18 there, I've removed that there's a limit on the number of card holders they can assist. And that's actually that's really about the only thing. If you go to page 2, it's the same wording. We're just removing it into different parts of the law. So lines 24 through 30. The current law restricts caregivers to only have three patients that they're providing for. The courts, when they got a hold of it, cited the same section. So I'm on page 10 that I handed out of that decision again, and it's section D. And then just towards the end of Section D there, lines 11 and 12, mentions that the limits on registered marijuana providers to no more than 3 registered users of marijuana, and then it cites the problem in the Constitution that it has with that. And it's the same lines that we read earlier, just a person's right to earn a living in property. And then there's some case law in there that I won't bore you too much with. But on the next page, or 2 pages later, page 12, lines 21 through 24, the ban on providers receiving compensation for engaging such activities, and to limit the number of registered cardholders each provider can serve substantially implicates the foregoing constitutional rights of providers and users of marijuana. The state concedes that preliminarily enjoining these sections may be done without affecting the integrity of the remaining provisions. So that was also enjoined because of a person's right to earn a living, and limiting to 3 caregivers was also a violation of that right. They cited the same exact part of the Montana Constitution on that one. We're doing well. House Bill 343. House Bill 343 is probably the one that I think has the most, well, my opinion's irrelevant. The thing that jumped out on me on this one is what we're doing here is we're going to eliminate inspecting and record-keeping requirements for those individuals who provide marijuana and marijuana-infused products to individuals with medical conditions. And there's a repeal. The repeal that we're doing here, and that's the thing that Sue handed out, this is the Montana Code that allows for warrantless searches by law enforcement individuals. So there's a couple things that goes on here. First of all, I've eliminated the record keeping, and that part of the law is currently enjoined as well, because it's a violation of a patient's, right to privacy. The fact that they know how much, who these patients are. I mean, there's no other medication that a person will ever cope with where law enforcement individuals can come and ask and find out if you actually have a prescription for something or not. So this was held up as a privacy issue. Yeah, I'll just leave it at that. This was held up as a privacy issue, that portion of it, and is currently enjoined and not enforced in the state of Montana. But also, if you pull out the section that Sue handed out earlier, there we go, the portion of Montana Code. And this was the inspection procedures, so you won't find it in the House Bill 423 because all we've written in there is that we're removing the entire section from the law. So this is line 9 on page 3 of the bill, repealer. The following section of Montana Code annotated is repealed. So it is that the part about the search and seizure. So it states that the department and state or local law enforcement agencies may conduct unannounced inspections of registered premises. The court's opinion of that one starts on page 8. In lines 20, it says, under the U.S. Constitution, however, all persons are protected from unreasonable searches and seizures. The right of people to be secure in their persons, their houses, papers, effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and the person's things to be seized. It further goes on to cite where the U.S. or the Montana Constitution also states that people shall be secure in their persons, papers, homes, and effects from unreasonable search and seizures. No warrant to search any place or seize any person or thing shall be issued without describing the place to be searched or the persons or things to be searched. It's almost a direct quote, isn't it? So this one was held up as a problem with both the U.S. Constitution and the Montana Constitution as a violation of the right to, or a prohibition against unreasonable search and seizure. Now, when I talk to members of the industry, and they might address this when they talk to you in a minute here, they're actually not opposed to folks from Health and Human Services possibly having coming and inspecting their premises and stuff like that. I think the fact that it's law enforcement here is why this is being held up as a violation of people's constitutional rights and currently enjoined and therefore not enforced. So it might be something that we can address down the road, to be honest, and have some level of examination, of these premises, but it probably should be done, health department kind of statutes rather than just an open warrantless search for law enforcement. So, ladies and gentlemen of the committee, that is all 4 bills. I will reserve my right to close on each of them, but with your permission, I might turn it over to the folks behind me now.
Okay, and you always have the right to close.
Yeah. And I am available for questions.
Proponents. All those that are in favor of these laws, if you're in favor of all of them, you can just state that. Please speak into the microphone and be able to spell your last name, or if your first name's unusual, please spell that also. Thank you, sir.
Mr. Chairman, members of the committee, my name is Dr. Pat Pardis. I've practiced chiropractic in the state for about 25 years. I retired about 10 years ago. I am a board member and the lobby for the MTCIA. We are the Montana Cannabis Information Association. We are the ones that have carried the lawsuit against the state. I wanted to let you know right today, our First Amendment rights are being taken away. We are an advocacy group. We are a political group. We do not deal in marijuana. We do not buy or sell marijuana. We are having banks deny us an account so we can pay our attorney.
Please stay on the bill, sir.
It seems very strange to be here today. About a year and 11 months ago, a little short of that, we were here in a legislative committee meeting over 161 when it began raining federal agents. Luckily, Montana politicians stood up for Montana citizens who were following Montana law. In no way do we condone the intent or the results of SB 423, because of the fact of the matter is, SB 423 was intended to put as many obstacles in the way of patients and providers as could be imagined. SB 423 was designed to reduce the number of patients and providers because the perception had become one of utter chaos. The chaos could have been provided by regulation, but it seems no one had a 10-foot pole short enough. The MTCI, as a plaintiff in contention of SB 423, has prevailed with a court injunction based on several violations of U.S. and Montana law. USB 43 has been ripped apart by the courts and now has gaping holes in it, all of which are constitutional issues we believe are valid. With these gaping holes, SB 423 does not remain intact as a viable law. These unanswered issues leave large gray areas for the law enforcement and for our people in the program trying to follow state law. Before you today, you have an opportunity to correct most of these constitutional issues. It would be so easy to put this behind us and go forward. SB 423 is far from ideal, but it appears we will be living with it until light either dawns upon the horizon or the courts throw it out entirely. Correcting these constitutional issues now would certainly prevent the latter. Regardless of your ideology, regardless of your party, I thank all of you for your service to Montana citizens. Thank you.
Thank you, sir. Further proponents? And please stand up if you'd like to.
Mr. Chairman, members of the Health and Human Services Committee, my name is Kathleen Shannon. I'm a Christian. I'm a business owner in downtown Billings.
Would you spell your last name, ma'am?
Shannon.
Thank you.
I have Crohn's disease as well as scoliosis, and I am a medical cannabis patient. I am in favor of HB 340 through 343. In Judge Reynolds' opinion, SB 423, without these four provisions enjoined, would serve no other purpose than to eliminate access to medicine by eliminating legal providers. There is no rational basis and would cause irreparable harm to the most ill patients. For myself, I have my life back with no toxic prescription medications. My health is as good or better by far, actually, than it's been in years, and the prescriptions for Crohn's are full of harmful side effects. My GI doctor at Billings Clinic assured me cannabis is helpful for autoimmune as well as inflammatory diseases, and there have been plenty of studies in other countries that back it up, is what my gastrointestinal doctor told me. To put it simply, I spend about 6 or more less hours in the restroom a day. If you're a patient with Crohn's, you understand how big that is. That's big. If I didn't have cannabis, I imagine I would no longer be able to work, and I would have to look at disability. My 87-year-old mother has been by my side through this illness, and we travel a lot, and she would like me to start leaving flyers everywhere we go to let other patients know how profound this plant has, how profound the effect has been for me. And I may have to do that. I thank you very much for giving me the opportunity to share this with you, and God bless.
Thank you, ma'am. Proponents?
Mr. Chairman, members of the committee, my name is Mort Reed. I'm from Billings. I'm here today speaking on behalf of the MTCIA. I'm a non-paid volunteer member of the MTCIA Board of Directors. In that capacity, I've advocated for medical cannabis laws that give the greatest consideration to the most vulnerable Montanans, the sick and the elderly. From 2004 to early 2011, a burgeoning medical cannabis industry saw the number of carded patients grow to more than 36,000, while the number of caregivers swelled to over 4,000. The 2011 legislature responded by passing Senate Bill 423. Senate Bill 423 was an overreaction by the Montana lawmakers in an effort to rein in an expanding medical cannabis industry. Some of the provisions of Senate Bill 423 were so onerous that they would have eliminated patients' access to their medicine by A, limiting the number of patients to 3 for each provider, B, allowing no compensation for providers, C, allowing unwarranted searches by law enforcement, and D, providing automatic investigation of doctors who made more than 25 referrals in a year. MTCIA responded by filing a lawsuit which successfully enjoined those provisions of Senate Bill 423. Those provisions have been under injunction since they took effect a year and a half ago. Today, there are approximately 8,000 carded patients and approximately 400 providers remaining in Montana. Senate Bill 423, as enjoined by the court, has been largely successful in reducing the number of cardholders and providers in Montana. The unintended consequence of Senate Bill 423, without amendment, is that it interferes with patients' end-of-life health decisions. That was certainly the case for Lori Burnham, who succumbed to her cancer in December of this past year. MTCIA is not asking for an expansive rewrite of the medical cannabis laws. We're only requesting that this committee codify what the court has already decided in an effort to avoid costly, wasteful litigation in the future. Thank you, Mr. Chairman and committee members, for allowing me to testify here today.
Thank you, sir. Proponents?
Good afternoon. My name is Penelope Strong. I'm an attorney in private practice in Billings, Montana. I have more than 30 years of experience both here in Montana and Wisconsin, and I regard myself, one of my primary focus areas is constitutional law and civil liberties. I am here to speak in favor of these 4 bills. I think they're very sensibly crafted.
Ma'am?
I have followed.
I'm sorry, would you spell your last name for us? I'm sorry.
Certainly. Strong, S-T-R-O-N-G.
Thank you very much. Please.
Welcome. I think that these 4 bills are very sensibly crafted. I think that they solve the problems, as mentioned by the previous speakers, the difficult legal issues that both the Supreme Court and Judge Reynolds have had to tangle with. And I would like to follow up in that regard and note that when the change in the law was wrought, there were a number of providers who were in a very, very precarious and difficult position because they ostensibly had to cut their patients' loads. I consulted with some of these people, and they were, I would say, traumatized by the fact that what were they going to tell their patients? On the one hand, they wanted to be in compliance with the law. On the other hand, they had very, very ill people with a variety of debilitating medical conditions who now legally, potentially, they could not serve. And I'm sure that you know the difficulty of growing marijuana, of producing it. And I would also like to mention that there are now procedures, there are technological advances that have been made where individuals who are competent in this industry actually can buy a $30,000 machine and they can titrate and make the dosages safe, and they can also standardize them. That has been a concern, I think a justifiable concern, of law enforcement, the treatment community, and legislatures such as yourself. So I think that Representative McCarthy has done an excellent job here of analyzing the current court case. And even over and above what the courts have done, I think that this is a sensible tailoring and, if you will, a rewrite of 423. The last thing I'd like to mention is that in my experience as an attorney, I sit on a board of national defense attorneys out of Washington, D.C., have been on that board for 6 years, and have seen a national landscape for cannabis that is changing. And with regard to the scheduling of cannabis as Schedule 1, which is something that was very significant to the Supreme Court, I attended the oral argument. It is a hindrance and a roadblock legally, but there is a bill pending in Congress to change that. We know that other states are decriminalizing, legalizing marijuana, as well as setting up medical marijuana schemes that are pretty well crafted, and that includes our District of Columbia. And I think that Congress actually has authority over that. So in the broader scheme of things, although I know you're dealing with Montana citizens' interests, I think in terms of federal law enforcement that we will see some sea changes in the next few years. And of course that is impacting the sick, the ill, people who are seeking to access medical marijuana here in Montana, not to use it for recreational purposes, but for fundamental constitutional human rights. Thank you.
Thank you, ma'am. Proponents, and please try to stay on the bill, or bills.
Mr. Commissioner of the Health and Human Services Committee, it's an honor to be here today to be able to speak with you about something I'm extremely passionate about. My name is Amanda McCormick, MCCORMICK, and I am from Billings. I am here speaking in favor of House Bills 340, 41, 42, and 43. I was diagnosed with type 1 diabetes at the age of 11, and I have been living with this disease for 12 years. And just the sheer fact I've had it that long, there are complications that arise, and the nerves in my stomach that help me digest food are damaged. And so about 4 years ago, I was in the hospital about 15 times in a 2-year span, and the doctors didn't know what to do, and they didn't know what was wrong with me. And finally, I had a physician that recommended the medical marijuana. And in the 2 years I've been a part of the program, it's significantly changed my life. I've been able to work again, and I graduated from college, and even on a trip to the Mayo Clinic, I found them extremely supportive of this medication. The issue with Senate Bill 423 is the fact that these 4 provisions will completely shut down the program as we know it and completely eliminate our access. And I feel that our access to this medication is one of the most important things, because most of us don't have the time or the finances or the space to grow for ourselves. We need the care providers to be able to grow us the quality of medication that's going to help us with our symptoms. For a lot of people, they suggest the alternatives, which are pharmaceutical medications, but I've had significant issues with that. I've had a lot of negative effects, and the side effects of the pharmaceuticals were worse than the actual illness that they were trying to treat for me. And so in turn, I was just treating side effects and treating side effects and treating side effects. And the cannabis has allowed me to quit taking those pharmaceutical medications that were destroying my body. Furthermore, by eliminating these 4 provisions, we will start saving all of our resources that we're pouring into this court case. And with this legal battle that's been going on as long as it has, we've spent thousands and thousands and thousands of dollars in people's time, when if we could eliminate these 4 provisions, we do have a a bill here that is workable. You know, it gives us a good foundation and a direction to go in to be able to provide a fair, honest, and comprehensive program for the people in Montana that really are sick and that do need this. So, although nobody expected the boom that happened a few years ago, we now have the opportunity to address these 4 issues and give us a workable program that can benefit many Montanans. So thank you for this opportunity.
Thank you. Proponents.
Good afternoon, Chair, members of the committee. My name is Nikki Zupanik, Z-U-P-A-N-I-C. I'm the Public Policy Director for the American Civil Liberties Union of Montana. On behalf of our nearly 2,000 members statewide, we support all 4 of these bills for the same reasons that Representative McCarthy and other proponents have already shared with you. Thank you.
Thank you. Please try not to repeat.
Mr. Chairman, members of the committee.
Spell your last name.
My name is Paul Matt, M-A-T-T. I'm an attorney in Billings, Montana. Over the past couple of years, I've represented clients under both...
Please move the mic a little bit closer to you, sir.
Okay, I've represented clients under both 148 and 423. When the 423 was passed, it essentially terminated the legal use of marijuana, medical marijuana in Montana. The court cases we've talked about, too, in the district court and the Supreme Court cases have ferreted that out so that there are 4 sections essentially that have been found unconstitutional or not, or have been repealed by joint agreement. Representative McCarthy has outlined that these 4 bills. Oh, I'm sorry. Representative McCarthy has stated that these 4 bills essentially follow what the district court injunction has set forth as unconstitutional and not allowing people in Montana to get medication that is legally allowed. I'm supporting all 4 of these bills. These bills are necessary for people who I represent to be providers and to be caregivers. Without these bills being passed, there will probably be further court litigation, which again, I believe has been hashed out enough. So I support these bills and I ask this committee to send it on.
Thank you, sir. Proponents. Any further proponents? Opponents.
Mr. Chairman, members of the committee, my name is Bruce McIntyre, M-A-C-I-N-T-Y-R-E. I represent the Billings Chamber of Commerce. We have over 1,200 member businesses that employ in excess of 44,000 people. This, 2 years ago, was the biggest issue that we faced. Senate Bill 423, while it may not be perfect, was the will of the legislature. Since then, the court cases have eliminated certain sections. However, the judicial process has not been exhausted. And I would encourage you on all 4 bills to allow that judicial process to go forward and vote no on these bills. Thank you.
Thank you. Proponents.
Good afternoon. Chairman Howard, members of the committee, my name is Candace Payne, P-A-Y-N-E, and I'm here on behalf of Rimrock Foundation. Rimrock Foundation is a private, nonprofit provider of treatment for substance abuse and co-occurring mental health disorders. They're serving over 4,000 patients annually in 134 beds and with a large outpatient program. Last session, the people at Rimrock, after they hired me, and if I'd have known they were going to do this to me, I would have charged them a lot more. They said, you go up and you testify on every medical marijuana bill that comes in. That has got to be changed. And so I did, and I'm pretty passionate about it. Marijuana is a gateway drug. It's the one that the kids in trouble start out with. It leads to further substance abuse problems. Scientific data from the National Center for Substance Abuse indicated that those states where medical marijuana has been legalized saw a corresponding increase in the use of this drug by adolescents. This finding corresponds with over 40 years of Rimrock experience at treating adolescents in trouble with substance abuse. last session, Rimrock provided me with what they entitled a legislator alert, and it is a little pamphlet on why treatment professionals oppose marijuana use. And with your permission, I'll start
Yes,
this
ma'am.
around.
Please do.
Or I'll give it to this. I'm a little concerned. Remember Paul Harvey and the rest of the story? Well, with all due respect to the sponsor, he has talked to you about a court ruling on this case. It was a preliminary injunction. Preliminary means there's been no trial. Preliminary is put in place to maintain the status quo until there actually can be a trial. The order that the sponsor referred you to was June 30th of 2011. Is that correct? Okay. Since that order came out, the Montana Supreme Court issued an order on September 11th, 2012, and then there was a subsequent determination by the State District Court on January 16th, 2013. And the combination of those does not leave the situation quite. It's changed a lot since June of 2011. The Supreme Court, in its 2012 determination, found that the district court had used the incorrect level of scrutiny in making its determination on the need for a preliminary injunction. The court reversed the district court order and remanded it back to the district court to apply the correct level of scrutiny to determine whether subsection 5046, 308, 3, 4, and 6 should be enjoined as unconstitutional. And so the Supreme Court didn't determine that it was unconstitutional. The Supreme Court determined that the district court needed to use a different test, so to speak. And they sent it back for the district court to make that determination. The district court has not made that ruling yet. It has kept the preliminary injunction in place. House Bill 340 is intended to only amend two sections of law, 5046-303 sub 10 and 11. Section 10 required that the department should give the Montana Board of Medical Examiners the name of any physician who provided written certification for 25 or more patients within a 12-month period, and then required the board to determine whether the physician had met that appropriate standard of care. Do you remember the cannabis caravans? This is an article from the Bozeman Chronicle, dated June 4th, 2010. I just want to read a little part of this to you. The State Medical Board is trying to curtail the mass screenings and recently fined a physician who participated in a similar clinic in the first disciplinary action taken against a doctor in a Montana medical marijuana case. The board found that the doctor had seen about 150 people in 14 and a half hours, or roughly a patient every 6 minutes, nowhere near enough to provide appropriate care in the eyes of the medical observers. And of course, the lead-in paragraph is, as Bob Marley music wailed in the next room, the makeshift clinic hummed along like an assembly line. Patients went in to see a doctor, paid $150, and walked out with a recommendation that they be allowed to buy and smoke medical marijuana. That's what we were trying to address in the 2011 session. According to a report prepared by Legislative Services, and I think it was actually done by Sue O'Connell, she said that, or in the report it says, since the new law was implemented, the number of individuals registered to use marijuana for medical conditions dropped by 72% from May 2011 through July 2012. The number of patients in May 2011 was 31,522. By the end of July 2012, there were only 8,834 registered medical marijuana patients. The number of minors with cards went from 54 in 2011 to 2 in July 2012. The number of caregivers in 2011 was 4,650 and was down to 395 in 2012. This particular section of law that is being addressed in House Bill 340 was enacted specifically to address the concerns of the medical community and to put a stop to the cannabis caravans. The new law is having a desired effect on getting the medical marijuana industry under control in Montana, and I really hope you will leave that little subsection alone. And of course, I was ready to testify on each one individually, so I'm also opposing House Bill 341. The underlying purpose of this particular section of the Montana Marijuana Act was to take away the economic incentive to grow large amounts of pot. This bill, just like House Bill 340, is formulated on the same district court decision and the subsequent Supreme Court ruling regarding the basis for issuance of a temporary restraining order in that court case. The Supreme Court reversed that decision and determined that while the Montana Constitution granted the fundamental right to pursue employment, no one has a fundamental right to pursue a particular employment or employment free of state regulation. The Supreme Court held that the 2011 Montana Marijuana Act does not implicate the fundamental right to employment. And I have copies of those other decisions. I don't know if the sponsor had those or not. The district court had also concluded that the restrictions in the Montana Medical Marijuana Act substantially implicated a citizen's fundamental right to privacy. Citing to an earlier decision, the Montana Supreme Court reiterated that an individual does not have a fundamental right to obtain medical care free of regulation, nor does the right to privacy encompass an affirmative right to access a particular drug or treatment. The Montana Supreme Court reversed the district court's holding that the Montana Marijuana Act substantially implicates the plaintiff's fundamental right to privacy. In January 16, 2013, the State District Court reinstated the preliminary injunction pending a final determination. To my knowledge, however, there's been no final trial on this matter. House Bill 341 is an attempt to supply statutory language allowing marijuana providers to sell as much pot as they want to as many people as they can. None of these actions are protected by the Montana Constitution.
Mr. Chair, I would object to the witness using the term pot. We're talking about medical marijuana, and I would appreciate if we kept it. It's not that the legislature sanctioned the use of pot. We sanctioned the use of medical marijuana, Mr. Chair.
I will refrain from using the term. I apologize if I have offended you.
Thank you.
Testimony opposing House Bill 342. 342 is aimed at limiting the number of card holders that each provider could serve with, which would substantially, the district court found that it would substantially implicate the Montanans' fundamental right to seek their health in a lawful manner. The Supreme Court reversed that determination and held that the 2011 Montana Marijuana Act did not implicate a fundamental right to seek one's own health because an individual does not have a fundamental affirmative right of access to a particular drug. The Supreme Court reversed and remanded the entire case back to the state district court for determination under the rational relationship basis. The district court reinstated the preliminary injunction, but has not had a trial or had a ruling on the final outcome. So I'm opposing House Bill 342 also. House Bill 343, Rimrock also asked me to provide, this is a position paper, a position statement on marijuana by the National Association of Drug Court Professionals, showing strong opposition to any legalization of marijuana use, and I'd like to provide this to the committee.
You may, ma'am.
Also, thank you. Rimrock is heavily involved in the drug courts in Montana, and they work extensively with them, and so they are really concerned about this. House Bill 343 its initial intent is to eliminate the requirement that marijuana providers keep records of their business dealings. As a lobbyist, I must comply with reporting requirements of the Commissioner of Political Practice. As legislators, you must meet the reporting requirements for campaign contributions. As taxpayers, we all must comply with the reporting requirements of the Montana Department of Revenue. Any one of us who is in business in Montana complies with reporting requirements as a consequence of doing business here. Anyone who makes their living in farming or agriculture, mining, or the oil field must make reports to the various state and federal agencies. If the providers of marijuana expect to be treated like other people who provide services and do business in the state, they should be required to provide appropriate reports to the state. The record keeping, however, does not seem to me to be the real problem in this bill. The sponsor of the bill provided you with a copy of the part that has actually been repealed. We had a former code commissioner who once told me, if you ever want to find the really bad stuff in a bill, look at the repealer section. That's where the dirt is. In its order of June 16th, 2013, the district court determined that sections 1, 2, and 3 of the section entitled Inspection Procedures would be temporarily enjoined. However, section 4 was not included in the original injunction. The other 3 sections are merely subject to the temporary injunction pending a trial and final determination by the district court. The Montana Marijuana Act was encoded in Title 50. Title 50 is entitled Health and Safety, and it addresses issues related to public health and safety. The Montana Marijuana Act was codified at that section at Chapter 46. Under Title 50 at Chapter 31, the law provides that the state has free access at all reasonable hours to any factory, warehouse, establishment, or vehicle in which food, drugs, devices, or cosmetics are manufactured, processed, packed, or held for introduction into commerce or for purposes of transport, in order to determine if there's been any violation of the provisions of the Montana Food, Drug, and Cosmetic Act. That is MCA 50-31106. Why is it okay that in the interest of protecting public health, businesses that provide food, drugs, or cosmetic are subject to unexpected inspections by the state, but the providers of marijuana are not? Also in Title 50, Chapter 5, regulating hospital facilities. Montana law provides that an authorized representative of the department may inspect a facility whenever the department considers it necessary, without prior notice to the owner or staff. That's it, MCA 50-5-116. Again, why is it that hospitals and regular health care facilities are subject to unexpected inspections by the state, but the providers of marijuana are not? Another one that is not as closely related, but still in Title 50, is 5079-107, which provides for entry at all reasonable times upon a private or public property within the jurisdiction of the department other than a private dwelling for purposes of determining whether or not there is compliance with or a violation of nuclear regulation. This bill also removes Section 4, which was not enjoined by the district court. Section 4 provides that a provider of marijuana-infused products shall maintain records showing the names and names and registry identification numbers of registered cardholders to whom mature plants, seedlings, usable marijuana, or marijuana-infused products were transferred and the quantities transferred to each cardholder. This section, I don't believe, was part of the district court temporary injunction. It merely parrots the amendment in the first section, getting rid of the requirement to keep the appropriate records of the business. The 2011 version of the Montana Marijuana Act has had the desired result of severely limiting the marijuana industry in Montana. In order to protect the public health of Montanans, the restrictions adopted in the Montana Marijuana Act need to stay in place. Please do not weaken this law. Vote do not pass on House Bill 342, 343, 341, and 340. Thank you for your time.
Thank you very much. Opponents?
Chairman Howard and members of the committee. Up? Better? I want to thank Candace Payne for her comments because it's going to dramatically shorten my comments since you don't want repetition. I am the co-founder and chair of Safe Community, Safe Kids. So I stand here representing thousands of people across Montana. And these are people who fought valiantly for SB 423.
Ma'am, please state your name and spell your last name, please.
Sherry Brady, B-R-A-D-Y. I'm from Billings.
Thank you very much.
And they did this because they understood the danger of this business proliferating across Montana. I also stand here as a mother of 5, though, and so my heart goes out to the children of Montana. And I would like to speak for them and to stand for the children who cannot be here to speak for themselves. The families and young people and children of Montana are in a position where they have to put their trust in the judiciary system. That means they have to trust each one of you to do those things that are right and that protect them. The dictionary defines trust as a reliance on the strength, ability, and integrity of someone else or something else. And you are in that position for the people of Montana. There is endless, mounting, credible evidence that marijuana is devastating to the undeveloped brain. And in that category of the undeveloped brain, the addiction rate is 40%. So exposure to this drug could adversely change the course of a life forever. So children and teens who come across this drug in their home or amongst their peers because the adults in their life have legal access to it could go down a road that there is no returning from. And they could go down a road where they could never reach their full potential, never realize real happiness or real joy, and not give back or be productive in this system, but be a drain to this system. And so there ends up being a lot of wasted lives. And in my opinion, there is nothing sadder than wasted lives. So I want to ask you ultimately, when this happens, who does the responsibility for that fall onto? Who is responsible for all of the wasted lives? So can I ask you, as you address these bills or think about these bills today, that you ask yourselves a couple of questions while you are doing it. Is what I am doing in the highest interest for the people in Montana? Is what I am doing in the highest interest for the children of Montana? Or is it in the highest interest of those few who use the drug or profit from this drug? The people have spoken loud and clear on this on several occasions. They don't want this industry in Montana. So as you look at these 4 bills, I want to ask you, is putting the money back into this industry in the highest interest for the people of Montana? Is taking the limit off the number of patients, therefore taking the limit off of how much they can grow, paving the way for large grows and black market again, is that in the highest interest for the people of Montana? Is removing the number of patients, paving the way for more medical caravans, is that in the highest interest of Montana's? Is eliminating any record keeping or any supervision in this industry, paving the way for black market again, is that in the highest interest for the people of Montana? I would say to you that it's not. SB 423 was written to give the people what they initially thought they voted for, and it needs to stay intact because it brings this industry under control in Montana. So I ask you to vote against these 4 bills and give the people of Montana what they originally voted for. Thank you.
Thank you, ma'am. Opponents?
I have
Okay, thank you. Can you help with those?
And it may appear that it is the same handout that you just received a few moments ago, but on the back side, there's a few more references that I will use. Chairman Howard and members of the committee, my name is Laura Needham of Billings. I'm also a member of Safe Community, Safe Kids, well, a co-founder, and I'm opposed to all four.
Please spell your name, ma'am.
NEEDHAM.
Thank you.
Everything I will articulate can be verified through this handout, with special attention paid to the National Association of Drug Courts professional position statement of marijuana. And the bills that have been put forward today treat marijuana as if it were not a legitimate drug. And let me explain by using maybe a little bit of humor. But let us imagine that those who would like to sell marijuana to the public ran commercials and had to disclose the risk factor as known by the current state of science, like they do on legitimate medicine. Such ad might state, some smokers may report serious symptoms of chronic bronchitis and other respiratory illnesses. How you administer this drug may lead to serious conditions, such as sharing a bong with a friend who has TB has shown to be an effective transmission of tuberculosis, a public concern. You should not use marijuana until you are over 25 or after your brain has finished developing. Side effects continues to include negatively affected attention span, memory, learning, and intelligence after the intoxication effects have subsided. Marijuana contains 50% more carcinogens than tobacco smoke. These carcinogens may or may not lead to cancer. Little humor here, but if you get cancer, mild death may occur. You should not use marijuana if you are predisposed to certain mental illnesses. Although we have no way of knowing, use of marijuana during adolescence is directly linked to the onset of major mental illness, including psychosis, schizophrenia, depression, and anxiety. 1/6 of adolescent users will become chronically dependent. As a result, some will suffer serious degradation of life success. Side effects may include poorer academic grades and a reduced likelihood of graduation. Do not operate machinery, as marijuana has been shown to impair the ability to function effectively and safely on the job and increase work-related absences, tardiness, accidents, compensation claims, and job turnover. Caution should you drive a vehicle. We have no sure idea at what dosage marijuana will impair your abilities to drive safely or how long your impairment will last. Marijuana use by parents is strongly associated with child abuse and neglect. This product is not FDA approved. Your grower may or may not have sprayed dangerous chemicals to ward off mites, which may lead to hospitalization. At the end of this commercial, you would not see an ask your doctor if marijuana is right for you. It would be consult with someone who grows your marijuana, who probably lacks a degree in pharmacy and has probably not spent one day in medical school. The NADCP opposes the legalization of marijuana, but they did say this: recommends drug courts receive convincing and demonstrate evidence of medical necessity, presented by a competent physician with expertise in addiction psychiatry or addiction medicine before permitting the use of smoked or raw marijuana by participants for ostensibly medical purposes. Clearly, we have a public safety issue, and these bills move into something in another form of cultural issues. Culture, as defined by my children's dictionary, is a group of people. The culture of a group of people is their way of life, ideas, customs, and traditions. Acceptance of medical marijuana without any pharmacy, without any training, results in just being drug dealers. In our society, it is a change of culture to recognize this. If we are not going to just repeal the whole thing, which I'm still in favor of, I would like to see all of these bills not pass your approval. Thank you.
Thank you. Opponents?
Chairman, members of the committee, my name is Mark Long, L-O-N-G. I'm the Executive Director of the Montana Narcotics Officers Association, and I'm here representing them today to oppose all 4 of these bills. We're an organization of around 150 federal, state, local law enforcement officers across Montana that deal with drug investigations, or at least have a focus there. I think everyone in the room here is well familiar with the issues, the negative issues, public safety issues and health hazards we had relating to the medical marijuana situation a couple of years ago. I'm not here to rehash that, but I think everyone knows that there were associated crimes with these things: thefts, burglaries, armed robberies, homicides, illegal drug trafficking, the whole gamut. Not to mention the illegal, or the folks that were driving while under the influence of marijuana and marijuana-related traffic fatalities. If you need to refresh your memories, I'm sure internet searches of the media reports back in those days will bring this right back to you. This legislative body 2 years ago, they noticed these problems. They dealt with these problems. They, and some of you are here, so that were involved in that, passed Senate Bill 423. Law enforcement overall is good with that bill. I mean, I hear people say that it's hard for law enforcement to enforce the current law, and it's really not. Certainly not because of the language in that bill. It's a pretty good bill from a law enforcement, public safety point of view. And since that law became in effect and is on the books, all those crimes that I just mentioned have drastically reduced. They've drastically dropped right off. We've been able to refocus our limited drug enforcement resources from that issue of marijuana over onto some other issues involving drug abuse. Montana is, without a doubt, a much safer place due to the passage of Senate Bill 423. And the current law, of course, was also affirmed and supported by the voters in November. These 4 bills right here, I think, would each take 4 giant steps backwards to the situation we had several years ago. These laws are vague, they're contradictory to some extent, they're ambiguous, and I think they would recreate some of those huge loopholes that we had in the situation a couple of years ago. This is not so much a prediction of the future as it is just a recollection of the history. We would be dealing again, or could be, with an industry dealing in large-scale productions of an illegal drug, a Schedule I controlled substance, large 1,000-plant, 2,000-plant grow operations, again, unlimited profit, untaxed, unregulated. With no record keeping, we would have no idea what was going on inside these grows, which is sort of the situation now. And no regulatory or compliance or inspection potential. There are a lot of provisions in Senate Bill 423 that are great tools to use, but we can't get inside any of these locations to see if they're actually being followed or not. We don't have that. I hear this referred to as sometimes as a warrantless search, but I don't know if that's accurate. I would say it's just inspection, compliance, regulatory checks like are being done all over. I can't think of any other business in the state that is allowed that free access to use a totally cash business with no record keeping. I find that a little bit bizarre. So, again, I just want to say that the narcotics officers oppose these bills. Thank those of you courageous enough in the last session to pass Senate Bill 423. It's a good law. It put the genie back in the bottle, and I just ask you not to do anything to help let that genie back out again. Thank you.
Thank you. Opponents?
Mr. Chairman, members of the committee, my name is Mark Murphy, M-U-R-P-H-Y. I represent the Montana Chiefs of Police Association and the Montana Police Protective Association, representing about 700 police officers statewide. It's hard to believe that this is the shortest medical marijuana line that I've stood in to testify in almost 3 years, but all of the hearings during the interim after the 2009 session and the multitude of bills that came in the 2011 session generally filled the rooms and most of the hallways to where they had folks directing traffic outside so people could get in and out to testify.
As this committee is well aware, the bills ranged from the bill developed by the Public Health and Human Services Interim Subcommittee under Representative Sands, that was House Bill 68, to Representative Milburn's House Bill 161, that was a full repeal of all of the provisions of the Medical Marijuana Act. The bill that was crafted, and law enforcement at all levels participated both in the interim and in the Free Conference Committee that crafted and created Senate Bill 423. There's been some discussion, particularly about this bill, House Bill 343, and some of the question is, why does law enforcement have the power to conduct warrantless inspections of these premises? The answer is very simple. Nobody else wanted to do it. The various bills presented in the 2011 session gave the inspection requirement to DPHHS, Department of Labor, even Department of Agriculture got the inspection in one of the bills, and when all of those politely declined, since there was no money to fund any inspection, it fell to local law enforcement. Truthfully, in this bill, it is unusual to have warrantless inspections conducted by law enforcement. That's because there's generally an administrative agency that is doing those kinds of inspections. There is no funding mechanism in Senate Bill 423, and so that task fell to us. And we are doing the best we can with the limited amount of power that we have and in compliance with the injunction. We all knew when we were working on Senate Bill 423 that litigation was going to occur. It was a compromise. That means nobody is happy with it. Could it have been much more strict in its appropriation, in its powers? Absolutely. It could have been Representative Milburn's bill to eliminate medical marijuana entirely. This was a compromise. The litigation is ongoing in this at this time. Any action by this committee, by the legislature, to throw out what Senator Essman did last session is premature. I would ask until final decision is made by the courts through the Supreme Court before the legislature takes any action on these 4 bills. Thank you, Mr. Chairman.
Thank you. Opponents?
Yes, good afternoon, Chairman Howard and members of the House Human Services Committee. My name is Jim Smith, here on behalf of the Montana Sheriffs and Peace Officers Association. I can be brief and limit my comments primarily to House Bill 343. And I'd say right off, I'm not an attorney, and it sounds like we're into the deep end of the legal pool on some of these questions and when the Supreme Court's going to issue a final order. But I'll say this. 2 bills last session. House Bill 68 that was crafted over the interim between 2009 and 2011, and House Senate Bill 423 that we've talked about today. Both those bills have these record-keeping and inspection provisions in them. And I'd ask you humbly on behalf of the sheriffs to keep these provisions intact. I would say over the interim, when people met 8, 10, 12 times to put together House Bill 68, that these record-keeping and inspection provisions were requested by law enforcement, but they were also requested and supported by the people in the so-called industry, by the growers and providers. And I think they wanted that level of assurance and quality control, as did law enforcement. They felt it was important to their operation or their endeavors. And I know that it would be important to you as policymakers and legislators, and important to the Montana public, that there be some quality assurance and quality control over the medical marijuana industry in the state of Montana. So we'd like to see those provisions kept intact at least until the Supreme Court makes its final decision. Thank you very much.
Thank you. Is there any further opponents?
Chairman Howard and committee members, my name is Susan Smith, S-M-I-T-H, and I live in Billings, Montana. I am grateful for this opportunity to testify before you today on behalf of Safe Community, Safe Kids, formed by a group of concerned mothers with a mission to inform and engage citizens to take action, supporting the higher law of the land towards preserving the safety, prosperity, and protection of our communities, families, in regard to the marijuana issue. I guess I might say that I have a lot of access to different issues and problems due to my age, first of all, in taking care of people that have been sick and dying, and also the fact that I'm a mother of 6 children and soon to be the grandmother of 26 grandchildren. So I understand that, and currently have a grandchild with ulcerative colitis / Crohn's, so I understand those and that pain that comes with those diseases, as well as myself having different things throughout my life. The future of our posterity is at stake. We also wish to acknowledge the voice of the people in Montana in regard to this issue, as has already been manifest several times in the past. We've already talked about these things. We've talked about the initial initiative, I-148, which, by the way, didn't include any of these concerns here that we're talking about today. And we talked about 161, the repeal. Again, another voice from the vote of the legislature, state legislature, as well as 423 and the supermajority vote in regard to that, which they were trying to put it back to what the initial voters voted for. And also including the failure of I-124, written by the marijuana supporters here, and the people of Montana have yet again voiced their concerns about this marijuana issue. It has been my prayer that those of you who are on this committee have researched this issue thoroughly. I know a lot of you are new, and have prayerfully considered the impact the passing of this bill would have on the people of Montana, not only now, but in the future. It's important to remember the past successes in history and mistakes, so we can continue in those successes and not make the same mistakes that have been detrimental to our society. We have come to a pivotal moment in history where the rubber meets the road. I would argue the validity of the bills being presented today, and obviously I would be in opposition to both of them, as well as Safe Community, Safe Kids, and thousands of people across the state of Montana. Based upon ancient principles Thomas Jefferson incorporated into the first 2 paragraphs of the Declaration of Independence, sound government should be based upon self-evident truths. I think Representative McCarthy referred to some of these, but I have some things to add to what he said. Truths that are so obvious, so rational, and so morally sound that their authenticity is beyond reasonable dispute. The government of mankind here on earth should be based on the law of nature and of nature's God. We hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness. And of course, all these are dependent upon condition. And I think all of these rights have been affected already by what has happened in regard to this marijuana issue in the last several years, and will continue to be affected if we don't take care of it at this time. That to secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed. In other words, the voice of the people, and the voice of the people has spoken many times in regard to this issue. They do not want it. With honest and just elected officials such as you, who would govern upon these principles, that will affect the people's safety and happiness. Among the most important of the inalienable rights are the right to life, the right to liberty, and the right to pursue whatever course of life a person may desire in search of happiness, property, and peace. But there is a warning, and I think we forget about that. So long as it does not invade the rights of others. I believe what has happened with the marijuana issue has invaded drastically the rights of others. The most basic reason for a community or a nation to set up a system of government is to assure its inhabitants that these special rights of the people shall be protected and preserved. As elected officials under oath, your duty and responsibility is to honor and sustain these rights. You have the power to champion these higher laws and protect future generations. Based upon these principles, how have the lives of the people, and especially the youth in Montana, been affected since 2009? What has been the result of this explosion of the marijuana industry? I think that has already been discussed today, and I won't go into that. But I would add that not a week has gone by since the marijuana explosion where some sort of crime has not been committed and has been reported in the newspaper and or local news stations across the state of Montana. According to the state officials, crime has increased in the state's jurisdictions since the issuance of medical marijuana, which would include homicides, robberies, thefts, assaults. And I'm sure that the federal government, when they came in to take care of these issues, had probable cause. We should be suspicious of anyone or a group who seeks to disrupt or abandon unity among the people. This is far from normal. It is debilitating. The equal liberty of all the people can only be maintained if such factions or groups can be controlled and prevented from gaining control of the powers of government to their own benefit, I might add, and at the expense of all others, which refers to what I talked about earlier in regard to life, liberty, and the pursuit of happiness. As a legislature, you are the checks and balances of sound government. Let us not become slaves as a whole to the consequences of poor judgment. It is important that we have a strong support of the importance of morality in promoting private and public happiness. There are standards that must be kept within a community to ensure validity, progress, and prosperity, as well as to protect the innocent, the weak, and the unsuspecting. It is nonpartisan. It crosses over and encompasses all. Morality is an indispensable support to political prosperity. So it would be morally wrong as members of this committee to pass these bills. There are certain corrosive elements that destroy and corrupt. One of these is debauchery of the moral fiber of society by commercial exploitation of vice, meaning drugs, illegal drugs such as marijuana. When the spirit of the whole is seriously abused, do not underestimate the consequences of the collective decisions that may be made without our participation to make it right. The real compassion in regard to this issue is the prevention of all social ills and the burden it places on society. Please don't discount the voice of the people of Montana and contribute to the demise of these principles that affect our lives, liberty, and pursuit of happiness. These rights cannot be taken away or violated without the offenders coming under the judgment and displeasure of God.
Mr.
And
Chair,
the innocent suffering from
I would just like to remind us that we need to stay on the topic of the bills. I don't think we're here to discuss the merits of medical marijuana, but actually the 4 bills that are in front of us.
I just want to add this one last thing, if it would be all right with you. I just want to appeal and to remind you of the larger importance of your task as it applies to all the people as a whole. For the sake of the future of our state and our precious children, do not rob them and or others of the ability to pursue life in its fairness. I ask you to oppose all of these bills. Thank you.
Thank you. Any further opponents?
Chairman Howard, representatives, I'm Steve Zabawa. Z is in zebra, then A, B is in boy, AWA. I come here representing Safe Communities, Safe Kids, as well as the Montana Automobile Dealers Association that represents all the dealerships and employees across the state of Montana. Been watching this issue for a long time. Our associations oppose anything that would reverse SB 423, in which we feel all 4 of these bills would do that. They're vague. They open up the door for all sorts of interpretations and money going and not taking notes and everything else that we worked so hard to get documented in SB 423, which was approved by both the House and the Senate. The people spoke. They also spoke again in November and voted down their opportunity to try to reverse the original SB 423. So I would like to see the judicial system move forward and see what the Supreme Court has to say about all this and enjoyment and so forth by a single judge. And nothing's really come to conclusion yet, so we should let the system do its deal. The other point I'd like to make is that is marijuana medicine? Just from a simpleton standpoint of a father and a car dealer and someone that's seen it wreak havoc within my family. I don't believe personally anything that helping maybe one person out of 1,000 not going through the normal federal rules allows us to move this state of Montana further, closer to where it should be. So I really would, just from a simpleton standpoint, would love to see the people that want medical marijuana to become reality to take it to where it deserves to go, to the federal government, in front of the Food Drug Administration, and get it approved and organized accordingly and tested correctly. And then if it is medicine, to come out through our local pharmacists that have been trained and our doctors that have been trained on that at that time, to be able to give it out to our people here. Is the state of Montana really think it's smart enough to hand out medicine? Have we ever done anything like this before? You know, we're setting ourselves up for failure. So I'm totally thinking that the whole thing still should be repealed, but that's not the issue today, so we're not going to go there. I think I've made my points. So bottom line, we're not in favor of these four bills to move forward as far as into the legislation process, and would love to see SB 423 stand as it is and see what the Supreme Court has to say about it. Thank you, Chairman.
Thank you. Any further opponents? Opponents, is there any informational witnesses?
Mr. Chairman, members of the committee, my name is Stuart Segrest, S-E-G-R-E-S-T. I'm an Assistant Attorney General and lead counsel in the lawsuit challenging the Montana Marijuana Act, titled Montana Cannabis Industry Association versus the State of Montana. I'm testifying as an informational witness only on behalf of the Attorney General's office. My goal is simply to provide a brief overview of the status of the ongoing lawsuit.
Would you pick the mic up just a little bit, sir? Thank you.
And answer any procedural questions that you might have. I'm not here to provide an opinion on the proposed bills to amend the Act or to discuss strategy or the likelihood of success on the merits in the ongoing lawsuit. Because the Montana cannabis case is in active litigation, I can only discuss what is currently in the public record. The current status of the case is that Judge Reynolds has issued a preliminary injunction as to certain sections of the Act. And I want to clarify something briefly. This has been discussed before. The original preliminary injunction order that Judge Reynolds issued, that Representative McCarthy read from and passed out to the members of the committee, is no longer a valid order. It was reversed by the Montana Supreme Court and sent back to Judge Reynolds to again look at the issue, this time under rational basis scrutiny, not strict scrutiny. And very briefly, strict scrutiny is the most difficult level of scrutiny for a law to meet. That applies in Montana to fundamental rights. And the Supreme Court specifically found that the rights involved in this lawsuit are not fundamental, in no small part because marijuana is illegal federally. Rational basis, on the other hand, is the easiest test for a law to meet. It requires only that the law be rationally related to a legitimate state interest, and that legitimate state interest can be any interest that the parties or the court can conceive of. It doesn't have to be what was actually specified as the interest in the legislative proceedings. So it's a very open standard, one that most laws meet. Where we're at now is that Judge Reynolds has again issued a preliminary injunction, but he did not do so based on the merits of the claims. He instead stated that in his opinion, the patients who were plaintiffs may suffer irreparable injury if the law was not enjoined pending the current action. And of course, at the end of even at the end of the district court action, once a opinion has been issued, the Supreme Court will still, or any party may appeal to the Supreme Court, who will most likely have the last word in this matter. So briefly, the sections that Judge Reynolds has enjoined: 5046-303 subpart 10, 5046-329 subparts 1 to 3, 5046-341, and 5046-308 subparts 3, 4, 6A, and 6B. As I stated, this case is far from over. A preliminary injunction, as its name suggests, is not a final ruling. Our office will continue to vigorously defend the Act, including the preliminarily enjoined provisions, as litigation proceeds. Once again, because the case is an active litigation, I will not be able to comment on questions that go beyond the procedural history of the case. Thank you.
State Street. Thank you, sir. Any further informational witnesses? Is there any questions from the committee? Representative Pearson.
Mr. Chairman, I have a few questions. I'll start with House Bill 340, Mr. Chairman. Could I get Ms. Strong? Mr. Chairman, Ms. Strong, on House Bill 340, it seems to me that an automatic Board of Examiners review of certain physicians that prescribe over 25 patients could be put into place to get rid of these caravans, quote unquote. Can you give me a legitimate reason why they should not be examined if they're prescribing for over 25 patients at a time?
Well, I think that there's a concern about a disparity, Representative, between a group of physicians who might prescribe medical marijuana and those who may prescribe any other sort of drug or medication in their practice. I do some licensing work with different boards within the Department of Labor and Industry. And I can also say that when a professional has something brought against their license, it can wreak havoc in their professional life, cause problems for their patients or their clients, and there certainly is a workload for the agency involved. I think also just setting a 25 patient limit, I think what the Judge Reynolds or a court may be concerned about there is that based on any empirical evidence? And if indeed there is a caravan going around, I think that the Board of Medical Examiners, if that's the correct authority, I think they're going to have sufficient jurisdiction and investigative authorities to find that out. You can see, as one of the opponents noted, that it was publicized, that apparently these type of things don't go on behind closed doors, so there aren't concerns about confidentiality and privacy. And also with the heightened scrutiny, now law enforcement has access to all of the medical card people. So I think there's some real legitimate concern about setting an arbitrary limit, both as to the numbers there and also compared to how a physician might treat someone in another arena with another drug. And I would point out another drug that's illegal, and I would also point out that, because I've done some of this type of work, that the DEA does scrutinize physicians with regard to hydrocodone, oxycodone, and those type of legal prescriptions that have now become a problem.
Mr. Chairman, follow-up.
Follow-up.
Mr. Chairman, Ms. Strong, I'm not a lawyer, so explain to me, is a review, an automatic review, an automatic black mark against a physician, or is it just that, a review?
I can't answer that without looking at the administrative rules. I would imagine that an automatic review, however, might mean some type of mandatory referral. For example, on the lawyer's side, if a lawyer is convicted of a crime, there is a mandatory referral to our disciplinary committee. And generally speaking, the Supreme Court automatically disbars that person. So that causes me some concern as well.
Okay. Mr. Chairman, a couple questions for Mr. Pardes.
Yes, sir.
Mr. Chairman, Mr. Pardes, in respect to House Bill 341, how are providers compensated now for each for everything that they sell at the moment, or do they do it for free?
Under the injunction, the provision that said that providers could not charge has been enjoined, and I believe that everybody is involved in capitalism, not communism.
Follow up? Mr. Chairman, Mr. Hardis, so what you're trying to say is with the injunction, they'll be doing it for free, correct? With this injunction to where they cannot be paid for their services, that means they'll be distributing medical marijuana to patients for free, correct? Is that what you're saying?
No, if the injunction drops, we will then go under the provisions of 423, and they will not be allowed to charge.
Okay, thank you. Mr. Chairman, one more question from Mr. Pardis, please.
One more question.
Or Ms. Strong, whoever wants to answer this one. Mr. Chairman, Mr. Pardis, on House Bill 343, to eliminate inspection and record-keeping requirements, how would any of these providers be held accountable for anything that may or may not possibly be illegally going on?
Yeah, I think we're under some real special circumstances here, and at the beginning of my talk, I tried to let you know the MTCIA is a political advocacy group. We are now losing our bank accounts because we are just associated and we have a political agenda with marijuana. The record keeping is a per se violation. When feds come in and you've got all the records for them, you've had a per se violation. And I think some of this is to really alleviate the discrepancy that we have between state law and federal law.
Mr. Chairman, may I redirect that to Ms. Strong?
Yes. Last question.
Representative, I'd be glad to answer that. I would point out that while this may delete the inspection procedures, and I have the code book in front of me, that doesn't stop law enforcement from proceeding with a warrant or on a warrantless search and going under other provisions. And I would also point out that there is a strict provision for unlawful conduct by card holders and caregivers that provides for criminal penalties. So it doesn't totally mean that there is no inspection. I can also tell you that there's a U.S. Supreme Court case, because I do a lot of search and seizure law, the Camara case, that says that actually you need less than probable cause when you are an administrative agency doing a health, safety, and welfare check. So actually, full probable cause, which requires meeting the search warrant requirements, is not always required, whether you just want to go in and do a check. I think the concern here, lastly, I would say, is we have completely unannounced inspection. There's no criteria. And, also DPHHS can provide under administrative rules, I think, for some type of regular administrative inspections that won't be so onerous, but on the other hand, will protect people's rights and give them notice. And the other last thing that is key to that is none of these four bills take out anything about the provision that law enforcement has access to the holders of cards. They have to keep that confidential. I think that's very wise. So they know their communities. They know when things are going on. And I'd just like to say that in terms of RIMROC's concerns about that, they need to put some trust in law enforcement to implement and enforce the laws that are within the current scheme. Does that answer your question in that regard?
Representative Smith.
Chairman Howard, I have a few questions for the sponsor, Representative McCarthy.
Mr. Chairman, Representative Smith, I will do my best.
Chairman Howard and Representative, as I go through my questions, a number of us have been involved with this for quite some time, as has Ms. O'Connell. So I'm going to bring up some things that are available to us so we can make a better decision on these bills as we review them in executive committee. So you may or may not be aware of some of the work that's already been done, but maybe we'll take and move along that, and it'll help you. On House Bill 340, where you had an issue with the number of card holders, or excuse me, the number of cards issued per doctor. Chairman Howard, Representative, do you have any idea what the average number of marijuana cards were being issued by each doctor?
Chairman, Representative Smith, I don't have those numbers in front of me. I have seen that in the past. I know that there is a broad range, and I think myself, as well as a number of people in the industry, are offended by the caravans that have been spoken or referenced a number of times. So I don't think anybody wants to see that come back. But in answer to your question, no, I don't know what the average number per doctor who issues those is.
Chairman Howard, Representative, would it surprise you, or did you notice that there was doctors that had recommended over 6,000 in a year's time?
That does not surprise me, no.
Just for everybody here, I'm sorry, did I interrupt you?
And I wouldn't condone that either, unless, because if you look at what a doctor's duty is, there's got to be follow-up care and things of that nature. I don't think my doctor has 6,000 patients. I'd be surprised if he can handle a patient load like that. So that would raise questions in my eyes if that occurred.
Chairman Howard, Ms. O'Connell does have some stats on what the average is by doctor. We don't know who the doctors are, but I've asked her to bring that to us when we have our executive actions, so you can kind of get an idea where the 25 came from, I think. The next question I had, you mentioned on, Chairman Howard, you mentioned on, Representative, you mentioned on House Bill 341 that there's no provisions for providers to get any seeds or marijuana or anything to that nature. Do you know if that was made, if that was provided for in the original initiative that was passed in 2004? How are they going to acquire their product when the original initiative was passed?
Mr. Chairman, Representative Smith, it actually, I don't believe it was cared for in the original initiative. And when we were looking into the laws of the various states, this is something that I think people are a little bit uncomfortable with addressing because while they made it legal, they never really made it apparent how a provider was supposed to come by his initial stock to get started. So when I saw that, I think my better judgment told me to leave it alone because it was going to raise some issues, but it didn't. It doesn't do justice to the issue of medical marijuana to not address where the initial startup of your product comes from. So I made the decision to come forward with that, and let's find a way to bring that into the legal realm. So, Mr. Chairman.
Chairman Howard, Representative McCarthy, this is an issue that I've kind of struggled with too. I'm not sure how as a state we could ever give you a legal way to acquire it when it wouldn't be legal federally. We might be able to say we're not going to prosecute state-wise, but for us to say here's a legal way for you to acquire it, how would we take and comply with any federal law that might be out there that I'm not going to be able to change? So how could I ever give a provider assurance that because we've told them in the states you can get your seeds, you can get your plants this way, it's legal, when it's legal maybe in the state or it's not legal federally? How do I address that issue, or how would we address that issue?
Yeah, Mr. Chairman, Representative Smith, as I stated in my opening remarks, I'm still acknowledging federal supremacy here. I'm not encouraging anybody to violate federal law. What I would like to do is have a framework that the state can use when that federal jurisdiction is lifted. I probably stated that wrong. The federal government is in the process, or could be in the process, of turning regulation of marijuana over to the states. When that occurs, there won't be an issue with where did that marijuana come from federally. There still will be an issue of where that marijuana came from within the state, because marijuana is still illegal to use recreational within the state of Montana. So what I was hoping to do is take the stuff that in the eyes of the state of Montana is in a legal realm now, and use that as where all legal marijuana comes from for medical purposes. That was my intent of addressing that. Did I answer your questions, Representative Smith?
Chairman Howard, I think that answers it. It still leaves the big question mark there for all of us.
Yeah, understand.
Chairman Howard, an additional question. I think we covered pretty well what the Supreme Court has decided, or has ruled on, what the district court has ruled on, and I think we're all pretty much in agreement that that's still up in the air. Is that correct?
Mr. Chairman, Representative Smith, I think it is up in the air still, and I looked at this as an opportunity to probably take this out of the courts and put it back in the legislature to fix what I think. If you read the original ruling of Judge Reynolds, very solid points about some issues with constitutionality. This can go on in the courts of Montana for, years if we let it. This was an opportunity to take it out of the courts, put it back in the hands of the legislature, fix a couple of the technical issues with SB 423, which SB 423 gave us the severability clause to address those, and just really kind of tie a ribbon around this and get it done and get it out of the courts. That's what my intent was, Representative Smith, Mr. Chairman.
Chairman Howard, Representative, moving to the last bill, when we're talking about unannounced inspections, just who under the current law can have an unannounced inspection? Can anybody that has a marijuana card, do you know, or?
Under the current law? Well, as enjoined, or assuming there was not an injunction?
Under Senate Bill 423.
Under Senate Bill 423, anybody who is a registered cardholder or a registered provider, so they had to be registered, but they were subject to the unannounced law enforcement inspection. Now that part is both of those have been enjoined, and I think one of our opponents made an excellent comment. When I read this, I said, why not the Department of Agriculture? Why not Health and Human Services? Why aren't they the ones inspecting this? But he answered the question for me, because we've never given the appropriations to those organizations to actually provide those inspections. I think myself, I'd be perfectly comfortable with it. I think it makes a lot of sense that there should be someone inspecting. I just don't like the fact that a law enforcement person can show up unannounced without a warrant. That stings a little bit, and I think that's why it's enjoined, because of the constitutionality of that problem.
Chairman Howard,
Mr. Chairman.
Another follow-up.
Last question.
There's 4 bills, Chairman Howard. If I remember right, Senate Bill 423, if you're just a card holder, if you're just growing for yourself, you are not subject to inspection. If you're a provider, you are subject to inspection. And if we could have somebody from law enforcement, I thought you had to have a warrant too. I could be wrong. I looked at a lot of different bills. Is there anybody from law enforcement that knows if you do have to have a warrant, or is it just an absolute surprise? You do not have to have a warrant. Okay, thank you. I was seeing some head shake back there. And our assistant, a question for another person. Representative, I would like to, your excuse for a moment, and I'd like to talk to the assistant AG that came up.
Mr. Sequest?
Sequest?
Segrest.
Mr. Chairman, Representative.
Chairman Howard, when we're talking about what's constitutional and what's not constitutional, could you tell us what the Supreme Court has decided at this point as to whether or not it's constitutional, and whether or not a person has a constitutional right to be in the marijuana business and selling it?
The Supreme Court has not addressed the ultimate merits, that is, whether these provisions of SB 423 that have been challenged are constitutional. What the Supreme Court has said is that there is not a fundamental right to access marijuana, and there is not a fundamental right to grow or provide marijuana. So that takes it out of the realm of what I was talking about with strict scrutiny and puts it into the much easier to meet level of rational basis. So they haven't addressed the ultimate merits, but they have said it's not a fundamental right.
Okay. Thank you.
Any further questions? Representative Gursky.
I have a couple, Mr. Chair. Actually, if I could speak with our federal agent that is here today. I'm sorry, I'm flipping through my notes.
We had somebody.
Isn't there somebody from the federal? Maybe I'm thinking of Mark Long. Pop up here. That's exactly who I was thinking of.
Would you please come to the podium? That's what Representative Gursky was requesting.
Okay.
Can you clarify your position? Then I am obviously confused.
I'm here as a representative of the Narcotics Officers Association. I am in law enforcement. I'm in drug enforcement, but at the state level, not
At the state level,
federal.
okay. I think that my question might still pertain then. Mr. Chair, Mr. Long, I have a few emails that say that there is a potential trigger point that the feds will raid certain providers that have affected both Washington and Colorado. And I'm wondering if you're aware of that trigger. What has been flying around is a 12-plant trigger in dealing with some of the states that have legalized marijuana. And I'm wondering if you or if there's anybody out there that could answer that question.
Mr. Chairman, Representative, no, I don't know. I don't know.
Is there anybody in law enforcement that can answer that? Or is that just going to go unanswered?
I mean, I think there are some triggers in other states, but what Montana, if Montana has one, and what that is at the federal level, I don't know.
Okay. I think a redirect then to Mr. Pardis, please. Mr. Chair, Mr. Pardis, if indeed, hypothetically, there is a 12-plant trigger on federal raids in other states, how many patients would that be for a provider?
Let me put it this way. The first documentation I saw about 2 years ago came from one of the federal attorneys, and it was a 100-plant limit for a grow operation. I just saw a letter came out from one of the federal district attorneys. I don't know that it was our district. I remember the name, Haig. Anyway, that was up to 200. But each federal attorney has his own discretion. So there is a federal district right now, the trigger is 200.
Okay. And then a question for Mr. Segrest, please. Mr. Chair, Mr. Segrest, I guess in listening to all of the testimony around the actual merits of what we're discussing today, around the legalities of it, I am concerned that we as a body are not, this isn't ripe yet for us. And I'm wondering if you can have that conversation with me a little bit. I hear that it's been in district court, it's gone up, it's been shot down, different level of scrutiny. Would it be presumptive of us to pass this legislation without a final opinion? And can you talk to the basically justifiable ripeness of cases before they reach either a lawmaking body, a legislative, or a court, or before a judge?
Mr. Chairman, Representative, I don't think I'm going to be able to answer the question as fully as you would like. I think that gets to really a policy decision. And at this point, because we are litigating this case, we don't feel like we are in the position to present policy for or against these bills. I will say that, as I mentioned before, the current injunction is preliminary only, and that means that there is ongoing litigation, and that at the end of the litigation, we will have a final ruling, and then that can be appealed to the Supreme Court. So it's far from over, and nothing that has been decided has permanently affected the legality of the law as of yet.
Can I have a follow-up, please?
Follow-up.
Mr. Chair, Mr. Segrest, if this body remains mute on it, I would believe that the cards will continue to fall as they are strategized to be in play. If we decide to act, how does that affect future decisions? Is that a whole new case? Does that change the direction of the case that's currently in play in the courts? How do we affect the legal systems if we decide in the middle of that system?
Mr. Chairman, Representative, If you pass some of these bills, you may what's called moot some of the issues that are at play currently in the lawsuit, and that means that, for example, as far as the 3-person limit, that is something that has been currently enjoined by the court and that is being challenged by the plaintiffs. If the law were to change and that 3-person limit were to go away, then that issue would no longer need litigating, so it would be moot. But that's a case-by-case analysis depending on whether one or more or any of the bills are passed.
Sure. Thank you.
I have just one question for you, Attorney. Is it Segrest?
Segrest.
Yes. I just wanted a kind of a decision on what your understanding of the law is. Is there a state law of going across state lines and bringing a federally prohibited drug into Montana?
Mr. Chairman, I'm not sure I understand exactly what you're getting
Let's say that I want to be a provider of marijuana. I want to grow. So I travel to California to buy seeds and plants and transport them into Montana. Am I breaking a state law?
I don't know exactly without looking at the law closer. I know that the law generally doesn't address where marijuana is originally obtained by providers.
Well, let's change it. Let's just say that I'm going to go get cocaine, and I'm going to go into Wyoming and buy it, and I'm going to transport it into Montana. Am I breaking a Montana law?
Yes, you are.
Okay. Now, let me ask you another question. What is the federal law that I'm breaking? Do you understand, or can you speak to that?
As to the original question?
It's transporting a federally illegal drug across state lines.
It's illegal to possess or to transfer Schedule I drugs, which include both cocaine and marijuana, across state lines, or even to possess them, whether or not you cross state lines.
Okay, so for instance, if I'm a provider and I want to go want seeds and plants, I'm breaking a federal law to transport those across state lines to grow it here. Correct?
I think that would probably be correct. Obviously, there are currently several cases against, some of which have settled against providers, and those issues are generally part of. Yeah, I guess my answer is it doesn't have to cross state lines for it to be illegal federally. It's illegal to possess or to sell marijuana federally.
My understanding is that was a separate violation under federal law.
That might be true, and I don't know.
Okay. Well, thank you very much.
Thank you.
Would the sponsor like to close?
Yes, I would, Mr. Chairman. Forgive me, I've been scribbling the whole time here. I hope I address a number of these things. First of all, Mr. Chairman, members of the committee, I would like to thank you guys for given the topic, an extremely orderly hearing, and we managed to run 4 bills at once. So, again, I thank the chairman for his cooperation up front. I do have to apologize to some of the proponents. I did leave them with the impression that we were going to be only doing 3 minutes of testimony. I don't know that they got everything out, so I do apologize for that. As it turned out, we didn't have that many people testifying, so we were able to get everybody in without restrictions. So I think I'll start with some comments Ms. Payne made, and I need to start off by lauding Rimrock Foundation. They're in my community. They do wonderful work, and I credit them with saving the life of a very close family member of mine. So I hope this doesn't sound like a criticism of what they do in the community. They do wonderful work, and I'm very grateful to have them in our community. But she did mention that marijuana is a gateway drug. My understanding is this is not supported anywhere. If we start going down that road, we can turn almost anything into a gateway, to include, tobacco, alcohol. I mean, if you really want to get carried away, it could be milk. Everybody has had something prior to trying something else. So I hope we don't use that as part of our consideration here. The caravans that we spoke to, Representative Smith, had alluded to doctors writing far too many prescriptions. I think we all agree with that. In fact, there's a number of things that I heard from the opponent side that I think we all agree with. And there's ways to address those through the Board of Medical Examiners. We can make a complaint. Anybody in this room can make a complaint to the Board of Medical Examiners and say, look, we think there's an abuse going on here. I would do that if I knew that a doctor was handing out far too many OxyContin prescriptions. There are abusive people in the system, and there is a way to manage those. So just speak to that. Let's see. She also mentioned, I think that the automatic review has now decreased the number of patients. The automatic review has never been enforced. So the fact that we have a decrease in medical card holders, I think is a good thing, and that shows that SB 423, as enjoined, is working. It's doing what I think the community wanted it to do. There's not an automatic board review right now, so that's not what led to the decrease in card holders. Let's see. Oh, good Lord, if you had to read my handwriting. Let's see. The inspection thing I think I addressed during someone's question. I think that's a good idea. I can't imagine having this industry go forward without some sort of an inspection element. I think that's an extremely good idea. We had testimony about how devastating marijuana is to the undeveloped brain, and that is absolutely correct. There are a number of things that are devastating to undeveloped brains. Some I mentioned already. The things the narcotics you can get prescribed to you are bad for you. Alcohol is bad for undeveloped brains, and so I wouldn't take anybody going into any course of medical attention lightly without understanding what the side effects are. So, medical marijuana is not above having side effects that should be considered by you and your doctor when going forward with the course of treatment. And I think I just touched that. I think that was a really good point made by one of the opponents, that there are side effects that need to be considered. Our actions today are not a repeal of SB 423. I think a couple folks mentioned that, and I just want to foot stomp this. 423 has done some good things in our community. It solved a lot of the problems that the unregulated industry or a lack of regulation caused. So 423 is working, but understand that 423 has never been in effect without the injunctions. So what we see as having resolved a number of the issues that bothered us are exactly how the medical marijuana industry is working now today. This is how it works. So we have only seen 423 under injunction. I think it's done some good things. I think other people have pointed out that it's done some good things. So all we're doing is trying to kind of codify the injunctions and move on as the industry is currently. Although I think we made some good points. There's probably some tweaks that should be made to include, but not limited to, having someone having that inspection authority. And with that, I think that's probably about all the useful scribbles that I've got here. So I'll just conclude with thanking you guys again for a great hearing. I want to thank all the proponents and opponents who've traveled to come here to get all the issues out on the table and stuff like that. And I just really hope that you'll do a new guy a solid, at least get me out on the floor with this stuff, and I appreciate that. So thank you very much for your time.
Thank you, and I also want to tell everyone that came, both opponents, proponents, informational witnesses. Some of you have driven as far as from Billings and even farther. This committee greatly appreciates your testimony. I mean, we can't do it without you, really. Thank you very much. This hearing is over. Committee, I'm going to real quick, I want to just remind you, Sarah sent everybody an email on the executive actions that will go down on Friday. These 4 bills will be doing
Chair?
executive action.
Mr. Chair, please don't say that these bills will go down on Friday.
Yeah.
Is that what I said?
Okay, we're ready. Sorry.
We will review these bills in executive action on Friday, all 4. And then, just quickly, I'll have Sarah also send another email out so you don't have to write all these down. But 101 we will be doing, and that's the one that is going to be referred down to the appropriations. 263, 306, 309, and 3119. 19. And like I said, you'll be getting an email. Any other business? Have a great night. Thank you.